Hey, everybody. Welcome to An Attorney and an Accountant Walk Into a Bar. I'm John. I'm the attorney, and my buddy here.
I'm Kent, and I'm the accountant.
All right. So, Kent, what are we going to talk about today?
The modern day method of securing your legacy, otherwise known as estate planning.
Estate planning. One of my favorite topics.
Let's get into it.
All right.
We're back. Well, first off, what is it again we're drinking tonight? I think it's Nika from the barrel. Japanese whiskey. I don't know if you're a huge fan of Japanese whiskeys. Feels like it's a growing contingency, but very smooth, delicious. And then when it's not leg day, you and I can imbibe it in a much more lucid manner. So today, we're going to talk about securing your legacy. And that means a lot of things for a lot of people, but ultimately, a big component of it is protecting your assets. And people know wills, they know trusts, but there's so many nuances to that, especially on the tax side. And what I love having you here for us to talk about is, as an accountant, my entire career, I've always built these tax plans around tax avoidance, mitigation, and I get to make these beautiful structures. But I was never able to do, since I'm not an attorney, is actually draft the actual trust and put it in place. So it's kind of like working with Legos in the mechanism, but never actually seeing the full, race car when it's done.
It's really an interesting field. I really enjoy working with this, and I enjoy doing estate plans for people. And I thought one of the things that would be constructive for us to talk about would be, well, what are people's common questions about estate planning? What is it that confuses people? And more importantly, what are the really, really important decisions and how people should go about making those decisions?
And I'd love to talk at some point about practicality too. So not everyone needs a complex trust or a dynasty trust, or have everything moved into different states or overseas. Complexity sometimes is the enemy of execution.
Absolutely. And I think one of the most important things that people need to understand, and I think this is one of the big ones that goes over almost everyone's head, is that a trust is a really important thing for people to have if they have a house. So if you've got real estate of any kind, you really, really need to have a trust. And beyond that, if you've got probably more than $100,000 or more in cash, or cash equivalents, investments and bank accounts and things like that, even if you don't have real property, you should have a trust. And why would you need this? Why can't I just have a will?
Right.
Well, the answer is, for you, it doesn't really matter too much, although it could, but it really doesn't. It's really about your heirs. So what do you care about? What happens to your heirs and what they have to go through when they die? And the basic trust that everybody should have that has real estate or has any assets at all is just your basic grantor trust, which, it's the pass-through entity and all that for tax planning and all that. But why do we want one of these? Well, the reason we want one of these is really two reasons. The main one is you need to avoid probate. And I'm sure everyone's heard, well, you got to avoid probate. You got to avoid probate. Well, what's probate? Well, one, probate's expensive. That's a really, really important thing to understand, is that a very reduced fraction of your estate is going to end up in your heirs' pockets. And the people who are going to get a good chunk of that is the California probate referee.
That's right.
The courts, and the attorneys. Now, my California probate referee is one of my favorite ones that people miss on. Well, what is the California probate referee? Why do they get so much money? Well, the California probate referee is actually a political appointee of the governor. And their job is to appraise all the assets in the estate. And they get a percentage of the total value of the estate. Well, what do you suppose their incentive is in terms of appraising the assets? Do you think it's to undervalue them? I don't think so. To value them fairly? Well, hopefully, but more than likely they're going to inflate the value.
Sure.
Because that's where they get paid. Now, who else gets a cut based on the value of the assets? The attorney, the probate attorney.
Got it. And the way that people avoid something like this, which is the important distinction, we're going to talk about this, a will, even though in a comprehensive estate plan, even at, assets at the most minimal level, meaning owning a house or having some level of collectibles, even of assets, the difference between a will and also a trust is that when we do estate planning, both still are in use. It's not that you do a trust without a will. Is that correct?
Yes, but the will's not the will that you think it is.
Mm-hmm.
And we'll get
what
to
kind
that.
of will is that?
Okay, so when we do a trust, we create another document called a pour-over will.
Mm-hmm.
And the pour-over will basically says, I will everything to the trust.
Right.
And it's really a safety valve.
So
it's not your
catch-all.
will.
A catch-all.
It's not your will.
Yeah.
Basically what it says is, hey, if I forgot something or I acquired something after I created the trust
Yeah.
and I left it out of the trust, I give it to the trust.
So it's important to note, anything that's in the catch-all, so let's say there was an acquisition of a car post, and it never got put into the name of the trust, and the pour-over will happens, does that asset get subject to probate or not?
Yes. Except if you have a trust
Mm-hmm.
and it was cleared that you intended that asset to be in the trust,
Mm-hmm.
which the pour-over will can actually perform part of the function of, instead of going through the whole formal probate with the California probate referee and all the fees and all that, you can open a probate and bring what's called a Hegstead motion,
Mm-hmm.
which is simply named after the Hegstead case, which allowed it. And the Hegstead motion basically lets the judge kind of like paper over the mistake.
And say,
And it's still an expense and it's still a cost, but now we're talking maybe $10,000 versus hundreds of thousands of
sure,
dollars.
big difference.
Big difference.
But I think it's important for folks to understand that it doesn't 100% involve probate. There's still some mechanisms involved.
You still, if you leaving assets out of the trust
Mm-hmm.
is the big mistake. It's the biggest mistake that I see come into our office day after day.
Mm-hmm.
There's two things that I do a lot of reviews of trusts. So I review other people's work, or I review what someone else has set up. In fact, that's a free service I offer. I'll review your trust. And one of the things I do is find out, well, what real estate do you have? And I pull property profiles with the title company, make sure that
Right.
the
Be thorough.
the title's vested properly. And then I go through it and I say, have another meeting with the client, say, hey, this is what your trust does. There's two things that happen, almost inevitably, believe it or not. One, there's property left out of the trust,
Sure.
which we can fix. But the one that shocks me, and I would say this happens 60% of the time, more than half.
Yeah.
When I explain to them what their trust says, they're like, what? That's not what I wanted. That's not what I told the guy.
Yeah, that's funny. I've been a part of those conversations, and it's somewhat, illustrative of some of the pet peeves that I have as a person that does a lot of that tax planning on the initial end for the estate planning. Is that two things happen. It doesn't function the way they expected it to, and the second is that their counsel never secured the fact that the title was changed for that property to put it in the name of the trust. So they have this paper, and it's a wonderful piece of paper, but they never went to the bank. They never actually changed title. The title of the property, there was no quitclaim being done. And so it's a great piece of paper that goes into the round filing cabinet, as we say. But what I'd love to hear from you is are there assets that you'd recommend not going into a trust?
It so much depends on the purpose of the estate plan, right?
Mm-hmm.
Oftentimes we do leave assets outside of the trust when they're best dealt with some other way. For instance, you could deal with a particular asset through joint ownership.
Mm-hmm.
Let's say you and I own a piece of property together, and you're my best bud, Kent, which you are, and I want to make sure that, this was Kent and I's hunting cabin,
Sure.
and I want Kent to have it. I don't want my kids to have anything to do with it. I'm not even going to put it in my trust. I could put it in the trust, and I could say Kent gets it,
Sure.
but I could just say let's do it as let's do a joint ownership where we are joint tenants
Yep.
with rights of survivorship, which means I die, you get it. End of
Yeah.
discussion. Perfectly fine to leave that out of the trust. There's no probate in the
Yep.
transfer, and easy peasy. And it doesn't end up, you don't end up having to monkey with and get mucked up with my trustee
Yep.
and them transferring title to you and all that. So yeah, there are times when it's appropriate to leave assets outside the trust.
I see that happen with clients with bank accounts typically. Sometimes they'll have an account with one of their children, or they have a couple accounts, and each of these accounts, each child might be joint account with rights of survivorship.
Right.
And so that's kind of like the back of the envelope way of leaving assets.
Here's the bad news on that.
Okay.
Kid gets in trouble.
Uh-huh.
Kid gets sued. Kid rounds up credit card bills. Who knows? Kid has an accident, runs somebody over, and they got a big judgment against them. That joint account is now subject to that judgment. They're liable for that. You're not protected in any way, shape, or form from the child's creditors, and the fact that, it's a joint account, the kid could just take the money.
Yeah.
So if you trust your kid and it's all good, that's all well and fine until something bad happens, that the kid gets in some kind of financial trouble, which children do.
Yeah.
And now that asset's at risk. So it's an okay way to do things, not recommended way to do things.
So this kind of leads into the when. A lot of folks don't like talking about morbid topics or morbidity, the morbidity of estate planning. But that illustrates for me that the conversation needs to be had during the course of someone's lifetime, not at the end of life, or not at a time where they think that the runway is shorter than it is longer. It is an open and should be an open and fruitful discussion, and evolving as a document throughout someone's life. So usually the best scenario that I see, at least from a tax planning perspective, is somebody is now an independent adult from their parents. They get a good job. They start to acquire an asset or assets, and they start with the grantor trust or the simple trust. And then as their life evolves, they might gain a partner in life, acquire more assets, enter into business deals. That trust starts to evolve, because it's not just about, hey, what happens when I die? A lot of it is, how do I mitigate taxes and essentially a lot of liability during my lifetime? And the function of trusts, where I want to get your ideas on is, or input on, is the asset protection during your life component of that.
Well, one thing we should understand with the type of trust that we started out talking about, which is your basic grantor trust, does not one diddly thing for protecting your
Very
assets.
important to note.
Not a damn thing. And most people don't get that.
That's true.
That's really important to understand. The IRS calls a trust a disregarded entity for
Grantor
tax
trust.
purposes, as you know, and therefore you don't have a tax return you file for the trust, and it's just your normal regular taxes.
Sometimes it's not even assigned a tax ID number.
Right. It's usually the Social Security number, right?
That's right.
And, well, guess what? Legally, in terms of whether it's your asset or not, it's also a disregarded entity. We use different terminology, but it's disregarded.
Yeah.
It doesn't matter. The fact that you have your assets in a grantor trust does not protect you from liability. Now, it does protect your heirs from liability in the sense that there are spendthrift provisions in the trust. So let's say, I have a kid and he has an interest in my trust, and maybe I died, maybe I haven't, because you can have interests in trusts that don't necessarily happen when you die. I could have, say, a special needs trust, or I could have, I'd say, hey, I've allocated some income to my kid in this trust, and kid gets in trouble, gets a judgment against them. Along comes a creditor, says, hey, I want a piece of Johnny's trust. I want that income. I can sit there and go, sorry, buddy, no. That's called spendthrift provisions. So there is some asset protection vis-a-vis the beneficiaries, but if you're the settlor or the creator of the trust,
Sure.
and you're a beneficiary of the trust, forget about it.
Yeah.
You're not going to get any asset protection. Now, there are trusts we do for that. There's irrevocable trusts, which is, topic for another day. And there's asset protection trusts, there's offshore things that we can do to protect people's assets. But that asset protection is a completely different topic than your basic grantor trust,
And in
which
this
is what,
case,
again, 99% of people need.
And in context of our conversation, we want to clarify that the grantor trust's primary purpose is to avoid the costly mechanism of probate.
Right. So let's talk about, just finish off that probate discussion. Cost, big one.
Yep.
Time, 1, 2, or more years
Yep.
to get through probate. Lack of privacy, all the assets are exposed to the public record. And it's an unfortunate position for your heirs to be in, because it's just a bleeding wound. You know, the fact that you've died is now this scab that keeps getting ripped off. You
Let's
know,
talk
because
about
it's going on or not. So probate we want to avoid. But there's one other really important component or purpose to your grantor trust that is almost never talked about.
What's that?
But it's really, really important. And that is that a basic grantor trust provides a mechanism by which someone can manage your assets if you become incapacitated. So not dead.
Aha.
So then this could happen to anybody. It could happen to me. I, walk out the street, I get hit by a bus. I don't know, I have an aneurysm. Something happens, and I'm in the hospital, hopefully for a limited period of time, couple weeks, couple months, who knows? But I'm unable to manage my affairs. Well, who the hell's going to pay the mortgage?
Sure.
Who the hell's going to pay the bills? Who's going to write the check? Well, you can't do it.
Mm-hmm.
You're my trusted financial advisor, but can't sign my name.
Exactly. Not
Right.
half.
But if I have a trust, I appoint a successor trustee. And that successor trustee might be my best friend here, Kent. And if that happens, you can then walk into the bank and say, look, here's the trust.
Sure.
Put me on the account. And until I recover, you can take care of me. You
Manage
can take
the
care
affairs.
of manage my assets. Really, really important, because if you don't have that, you're going to go to court,
Yeah.
and you're going to have to get a conservatorship over me so that you can then manage my affairs, and that's costly and lengthy and ugly. So that's a really, really cool mechanism. And of course, in a husband-wife situation, they each one's supporting the other. Usually the wife's the successor trustee.
Sure.
or the co-trustees, so they can manage each other's assets for them. So it provides a nice little mechanism there. But, typically one spouse dies first,
Mm-hmm.
and there's some period of time, sometimes many, many years, where there's a widow or widower situation, in which case that person gets put in the hospital. There's nothing. There's no backup at all.
I'd love to get your input on the type of estate plan that we're talking about at the most basic but essential level. There's a lot of terminology that just abounds on the internet. It gets thrown around in overall banter, and the nuance of mixing things up between wills, trusts, complex trusts, estates, foreign trusts, all kinds of. We even have acronyms, right? ILITs and GRATs,
Q-tips
reverse
and
GRATs.
Q-perts.
Yeah, of course. But let's start
Springing
with
trusts.
Yeah, exactly.
I hit my staff with an explanation of springing trust the other day, and everyone got really excited about it. It's kind of
That means we have
rather banal subject.
Well, then you have the right team. We're passionate about the things that we do. What I'd like to go over is what are some of the common key terms that are just bantered about, and what our interpretation of is it. So one of the most common term that right in the name of trust is trustee. So I think the choice of trustee is important. In this case, successor trustee, because in a grantor trust.
Let's get to that, but let's back up a second and talk about what you first opened the can of worms with. Because you're 100% right. There's all this
Noise.
information and
Yeah.
noise on the internet. And I see this, clients come in, they're confused.
Mm-hmm.
John, can you explain to me what a Q-tip trust is?
Yeah.
I'm like, what the hell do you care about a Q-tip trust for, buddy?
Yeah.
You got $5 million in a house.
Yeah.
I mean, that's good, but
Yeah. Doesn't make
you
sense.
don't need to know about dynasty trusts or Q-tip trusts.
Yeah.
You don't need to know about Cuperts or
Blind trusts.
or blind trusts or ILETs.
Yeah.
You don't need to worry about that stuff. Just put it out of your head.
Yeah.
Now, if you are in a situation where you have a potential taxable estate, that's a whole nother can of worms.
Sure.
And then we bring in all those acronyms and we bring in all those special trusts. And most people, even attorneys who write them, don't really understand them. So it's really important, if you're in that level, you got to have the right guy.
That's right.
And you got to have it shouldn't just be an attorney. You should have a tax person too. You really need the tax backup on that.
As a quick plug, though, I think there was a podcast that we filmed or we recorded about choosing the right professional.
Yep.
If you guys haven't watched that, click a link, watch that. That's an important, call it core concept knowledge base that people should have before they get into the discussion of estate planning. Are they working with the right person first?
Yeah, that's essential.
Yeah.
That's a whole nother topic. But
Okay, so
so I just wanted to clear the air on that. So
Sure.
please, it's what doctors go through, right? Remember,
Yeah.
I don't know if you ever see a House MD, but his favorite one was,
Yeah.
"Oh, you diagnosed yourself with that on the internet, did you?"
Yeah.
You know? Well, what else do you think you got? It's of course being very condescending, but that's a similar frustration that we face with attorneys now with all this information out there. So, if you don't have $13.5 million just to say hello, forget about all that other stuff.
Yeah. Yeah.
All we're talking about is your basic grantor trust. So, that being said,
Let's talk about terminology.
who's a trustee?
Trustee. So what's in a trustee?
What's
right?
in a trustee?
A lot of folks think, oh, it's my trust, and let's talk about successor trustee, for example. In this
Successor
case,
trustee is a good one. So, first of all, let's talk about what a trustee is. So, technical legal, help me out here a little bit.
Mm-hmm.
You can fast forward if this gets boring. But when we create a trust, it's essentially an agreement.
That's right.
It's not an entity. People treat it like an entity, but it's not. It's really a trust arrangement. It's an agreement. And there's 3 parties to the agreement, as it were. There's the settlor,
Which is the person that
which
created.
is the person that creates the trust, or the person that funds the trust, the person who puts property into the trust.
Mm-hmm.
It can also be the trustor. So settlor, trustor, same thing.
Got it.
The second party is the trustee. The trustee holds legal title. So they have title to the property. They have legal title subject to the terms of the trust.
Mm-hmm.
And then the third party is the beneficiary. That's the person for whose benefits the assets are being held. So the trustee holds the assets, administers the assets for the benefit of the beneficiary. Now, when you create a basic grantor trust, it's kind of like, the Holy Trinity in a way.
Yeah.
It's three gods in one.
Uh-huh.
You're the trustee, you're the beneficiary, and you're the settlor. You're all 3 things.
Sure.
Now, what does that do? Well, it essentially means that when you're alive, you can do whatever the hell you want.
Right.
So if you're alive, you've got capacity, it's held for you, you put it in there, and you're in charge.
Right.
So what? So what happens when you can't be the trustee anymore?
Mm-hmm.
Well, if you're still alive, you're still the beneficiary. It's still for your benefit. You're still the settlor because you created the trust, but we're going to change that trustee, and we're going to create the successor trustee. So they're going to succeed you as trustee. And that person is going to step into your shoes and have legal title to your property to manage the property for the benefit of the beneficiary. And if you're still alive, that's for you.
Yeah.
If you've passed on, the beneficiaries are also successor beneficiaries. The successor beneficiaries are your heirs. So settler's dead, so they're out of the equation. So now you've got a 2-party agreement where you've got a trustee
Sure.
and you have the beneficiaries. And the trustees manages the property for the benefit of the beneficiaries. So that's what we mean by those terms. And I think what you brought up there when you talk about successor beneficiary is probably the stickiest, most important.
Successor trustees.
Yeah, that's the big one.
Yeah.
selection of a successor trustee, making an error in that regard, making a misjudgment in that regard, is what always leads to disaster with these arrangements.
Leads to a lot of contention in family groups. A lot of folks, sometimes they make the assignment based on not wanting to make other people upset.
Yes.
A lot of clients,
Political reason.
exactly, internal politics within their family, saying this person will be able to control. But what clients don't realize that it is such a responsibility to manage the affairs, because once someone has passed, it is like a business. There is trust accounting and reporting that needs and should happen. Tax returns that need to be filed, documents that need to be organized and filed timely between any death tax returns, settlement of any estate outstanding bills, to get to the point where the beneficiaries can reap the fruits of that trust. And that is a business. And a lot of times when they have somebody that gets thrust into that position and they have a life of their own, and they're trying to start to administer the estate of a loved one, especially through grief, it gets messy.
Yep.
There's typically mishandling of assets. There's incomplete documentation. And what happens? The beneficiaries, if they feel that they've been shortchanged or awry, you start to create legal ramifications for misuse or misalignment of the trust. And the trustee was just trying to help out. The trustee's in a position where they're just trying to do the right thing, but they were never in a position to execute the nature of the trust. Now, again, depending on the complexity of the assets within the trust, it could be a moot point where it's just the house, sell grandma's house, we're going to be all set.
Yeah, a house and a bank account, probably not a big deal.
Sure.
But there's two things there. The first one you hit upon solidly, Kent, and that is competence.
Mm-hmm.
So we have to look at what's the complexity of the estate. Is it grandma's house and a bank account? Well, if that's the case, then maybe, the son can do it.
Mm-hmm.
Depending on who the son is, though. On the other hand, you could have a very complicated estate, and, well, the son's a CPA, and he's a businessman, and he's a really stand-up guy, and, well, son can handle it. Or brother-in-law, or friend.
That goes
So
into
that's so competence, so the ability of the person. Mm-hmm. So you have to, that's what I counsel clients on so importantly. These are the things that this person is going to be expected to do for you. One, well, yeah, they can get paid for it, but do they want to? Do they have the time and the energy to devote to managing your estate? And maybe, again, if it's just selling the house and distributing a bank account, not a big deal. So do they have the time? Do they have the ability? Are they competent? Do they have a business, some degree of understanding of business and how to deal with banks and taxes and all these things? Well, that's important. They can always hire professionals too. I mean, I've had plenty of trustees I've had to hold the hand through, but then guess what? Now you're running up costs again because now you're paying the attorney again. Yeah. Not anywhere near what a probate would cost, but still, you're paying the attorney. So that's really, really important. But then there's another element there that you gotta get: trustworthiness.
That's right.
So important, because this person is going to have legal title to your assets.
That's right.
Can they take all the money out of the bank and go to Mexico? And the answer is yes, they can.
That's what
there's nothing stopping them.
Absolutely.
Except for the beneficiaries filing a lawsuit and getting an injunction and all that. And if the person's already stolen blind by the time they get around to it,
usually by then there's not enough funds in the trust. And also the trustee, we've seen it happen, uses the trust's funds, further diminishing it, to defend themselves in a lawsuit from the beneficiaries.
Yes. So selection of the correct trustee is really, really important. And if we really can't get to, when I'm advising clients, we can't get to that person that has those qualities and they're confident in those qualities, then I strongly urge them to select a professional trustee.
That's right.
And that could be their accountant. It could be a CPA friend. It could be the trust department at a bank.
Yep. We work with that a lot.
And, there's plenty of professional trustees out there that are licensed and bonded. So if you pick the trust department at a bank, it's going to cost you. They're going to have some fees associated with it. It's pretty reasonable. Mm-hmm. It really is. And we have trust departments we recommend, and we've looked at their fees and their schedules. Can they steal the money? Sure. Are they going to? Probably not.
Yeah, more likely
And if
than
they
not.
do, they're licensed and bonded, and they have insurance.
Yep.
So, if you pick your CPA and he's got professional liability insurance and he takes the money and goes to Mexico, well, the insurance company is going to pay for it.
That's right.
Right? So at least there's something there. Whereas if you pick your brother-in-law who turns out was a scumbag, he probably doesn't have insurance.
Doesn't work out so hot. But, that leads me to an adjacent question. Can the trustee or successor trustee also be a beneficiary?
Yes.
And when that happens, does that add more mud to the water?
If there's a conflict, it can. You wouldn't want a successor beneficiary or a successor trustee to be a beneficiary if it was a trust that was going to continue beyond distribution. So there's two things that can happen with a trust. What you want to happen, the ideal situation is you die, trustee sells the house, gathers the assets, writes everyone a check according to your testamentary provisions, files the final tax return, done. We're out. That's actually happens quite smoothly most of the time.
Yeah.
There's times that can't happen. You have minor children. Or, more commonly, people say, I got $10 million here in my estate. I've got 2 kids. They're both a couple of fuck-offs. And I don't want them seeing any of this money until they're 35,
Sure.
40, right? And, of course, what's funny is that when you talk to them, they're always gearing it by their own behavior, right?
Yeah.
You can see what was I like when I was 25.
Yeah, you're like, I shouldn't
have
be
had
possessed
that
of this kind of
money.
money. For
So
sure.
more often than not, people with young children or even young adult children don't want that money to get into their hands for some period of time.
Sure.
So if that's the case, that trust is going to be an ongoing operation for perhaps years, 10 years. I mean, if your kid's 20 and you don't want him to have it till they're 30, there's going to be 10 years that the trustee is managing that estate, managing the funds in that estate, and making distributions to the beneficiary, usually for their health, safety, welfare, maintenance. Hey, I want to go to school, Uncle Trustee. Oh, Uncle Trustee, I need a new Ferrari. No, you're not getting a new Ferrari.
Yeah.
But you can go to school, but you're not getting a new Ferrari.
Yep.
That's the kind of decisions that the trustee has to make. And a really good arrangement for that, by the way, is what I call a professional trustee with a co-trustee that's like Uncle Joe.
That's right.
So Uncle Joe knows the kids. Uncle Joe can interface with the kids and find out what their needs are, but the money's with the professional trustee,
That's right.
and they're managing the funds. So Uncle Joe doesn't have, daily obligations to managing the funds,
Right.
but he can act as an interface or go between the kids and the professional
and
trustee,
manage that
that's
relationship.
a really, really good arrangement, by the way. Side note, but yeah, I mean that's this whole thing is that's when things get messed up, is when you get a bad.
Let's take another
successor
look
trustee.
at the lens of the beneficiary, because trusts that start out as a grantor trust upon death can convert, right? That trust can, at time of death, does it always become irrevocable?
Right, of course it has to, because the only person that can revoke the trust is the settlor, and the settler's dead.
It's key to kind of talk about that terminology. So grantor means during life, that person who's the settlor, who's also the trustee and beneficiary, can do as they will. But as soon as that person passes, that trust and successor
it
trustee
becomes irrevocable.
Yeah.
And then the successor trustee, has an obligation to, one, manage the assets for the beneficiaries, and to follow the instructions in the trust. And the instruction in the trust could be something as simple as a third. I got 3 kids, everyone gets a third, end of discussion.
Yeah.
That's actually what I see 90% of the time. You get 3 kids, third, 4 kids, 25%, 20, the whole thing. And of course, sometimes there's, that one kid's a son of a bitch and I want him cut out. All right, then it's 50-50, whatever. That's easy.
Yeah.
And in that case, again, all the successor trustee has to do is liquidate the assets, file the final tax return, cut everybody a check, easy peasy, go away. But in the case where you've got young children or you have some reason that the trust continues, yes, the trust is at that point irrevocable and really unamendable because there's no one to amend it unless you've appointed a trust protector. Then the trust protector can make modifications to the trust, which is another office.
So
but
we'll
there
have to talk
can be
about
in the
that.
trust. But those usually come up in the context of your irrevocables and your
Sure.
QPerts and dynasty trusts and the more complicated stuff.
Have you seen grantor trusts, call it spin off into, let's say there's two children, into two separate trusts?
Oh yeah,
the time of
absolutely,
death.
absolutely. So these are called springing trusts, and we can create a trust where it says, okay, I've got two kids. I have Johnny and I have Diane, and when I die, the trust becomes the Johnny Trust and the Diane Trust.
Mm-hmm.
And the Johnny Trust is going to get administered like this, and the Diane Trust will be administered by that. And you can even have different trustees.
Absolutely.
You know, I got Uncle Bob and I got Aunt Jane. Uncle Bob hates Johnny, so we don't want Uncle Bob managing his assets. So we'll put Jane in charge of that, but I really want Bob to take care. Yeah, that's just all.
So if we map that out, we're talking about a grantor trust, one of the simplest types of trusts, turning into an irrevocable trust just as a function of the passing of the grantor, of the settlor, creating two irrevocable trusts now for, in this case, the two children in our example. And those two irrevocable trusts could be complex trusts.
Okay.
They could just convert themselves into more complexity.
Yeah, absolutely.
So it's good. It's good for our listeners to understand that as it starts one way, it can still develop into a level of complexity. Given the right set of assets in the mix of individuals.
And this is the attorney's job, and this is what a good attorney is going to do, is they're going to figure out, spend some time with their client.
That's right.
What do you want to happen? What are your concerns? How do you want things to be? Don't worry about whether you can do it or not.
Mm-hmm.
Dream it. Tell me what your dream is, and I will endeavor, within the confines of the law, to draft a document that fulfills that's going to fulfill what you want or what your envision is for you to happen with your estate. And so I get those questions. Well, can I do this? Can I give it? What can I give it to? Can I give it to charity? Of course you can give it to charity.
Yeah, that's right.
You can give it to whatever you want. You just tell me what you want, and we'll make it happen. So, and that's when, you can start getting more and more complicated. And of course, the drafting starts to go up in cost too, and when we start getting more complicated. But even a basic grantor trust can become very complicated.
I love it, John. I love that byline. You dream it, John will fulfill it.
That's right.
We'll have to hold you to that. At least in the confines of estate planning, of course.
Hey, I've had people that wanted their heads frozen.
You know what?
Because they were sure they were coming back, and we took care of it.
I've definitely seen strangers as well in my career. So if we have listeners that are just interested in broaching the idea, especially at the foundational level that we're talking about today, about estate and trust planning, what do you recommend? Because listen, we're not for everyone as a firm, right? We work with certain types of folks, and some folks don't want that full service. But if someone is saying, hey, you just said the internet's full of crazy ideas, where should I go, or what do you recommend for a listener to say, how do I get the good stuff? Because as we're going about life, and we'll talk about this as an adjunct to another episode, is why don't I just put my assets into ChatGPT and have it whip me up a trust, and then we'll get that, up and running. That's potentially a possibility as we evolve in technology. But let's start with the basics. As we sit today, if you had somebody that said, hey, and I got a little bit of assets, I'm just starting out, what's the best way for me to figure out what to do?
I think people absolutely can figure this stuff out for themselves.
I agree.
But do you really want to? Do you really have the time and the energy to do it? And what I would say is, for anyone who's got a reasonable income and a house and some money in the bank or an IRA, come on, man. You can cough up $2,500
Yeah.
to have an attorney do it for you. Really? I mean, come on. It's not that expensive. The Tacsis, we notarize your deed for you, and we record it for you.
Yeah.
And it's done. So we make sure that it's done, and we follow up to make sure everything's done. And that's the difference between, a full-service firm and someone who's just a paperwork mill. And you can say one's right or one's wrong or one's good or one's bad. You get what you pay for.
That's a good adage, because the idea is that what is right for that individual? And then it goes to, again, level and complexity of assets. If somebody has simply a single family home and, your typical bank account assets, it is very possible to do that on your own. It's not the most complicated thing in the world. Just like on my end, doing your taxes. People can do their own taxes, file
But
their
do
own
they
return.
want to?
Again, do they want to? And it's about knowing yourself and understanding what value there is for getting it done right and seeking professional help. Look,
I 100% agree that if you've got a simple situation, your assets are under $13.5 million, you've just got a couple pieces of real estate, and you're willing to invest the time to really read through the documents, really understand the documents, really put some effort into drafting the clause that's going to say how your assets are divided. We call it the testamentary provision. You can absolutely do your own trust, but you've got to dot all the I's, you've got to cross all the T's. So, if you're an Northrop engineer and you're like a really anal retentive dude and you're going to really get into the weeds on this thing and you're going to make sure that the thing gets recorded and you're going to check all your titles and you're going to check all the boxes, good for you.
Yeah.
You can do it 100%.
Yeah.
Never seen it happen. Never seen it happen that it's done right.
Few and far between on that.
Well, because what happens is people start off with these things. They get the document.
Yeah.
They download it from LegalZoom, whatever. They sign it. Maybe they get it notarized. It goes in a drawer.
So let's talk about this.
They don't understand the thing about the deeds and, how to draft a deed to their house. That's not easy. That's a daunting task.
That's true.
You have to draft a deed for your real property that has a proper, description in it. It's got, all the places for the stamps and everything with the recorder, and you've got to get it notarized, and you have to make sure you know who it is that's granting and who it is that's granting to. Can you figure that out? Yeah, you can figure it out. Odds are you're not going to figure it out right.
It's kind of like a buyer beware. You can do a lot of things yourself. Like I could, weld a rack to the top of my car on my own, but I don't know lick about welding. I probably shouldn't do that. But
you could figure it out, but there's an investment in figuring it out and buying the equipment. Right?
Yeah. So the time value of money is dependent on what you have as a economic trade-off for your time. And I say this to a lot of clients too, that says, and it might not be your forte, but if you want it to be your hobby, right, and your side gig, go for it. And I'm happy to give tools. And there's plenty of tools on the internet. My advice is threefold. I'm very linear when it comes to that. Is step one, step one is watch our video on choosing the right professional.
Well, of course.
And
that goes without saying. You really want someone that does this.
And step two is educate yourself. Now, I know this sounds archaic, but there's the ability to go and actually read books. There are texts out there from, call it educational sources, so scholastic sources, not the self-help book arena, because there's a lot of that, and also finding all your information off of TikTok or the Reels. I would recommend, believe it or not, even potentially going to your local university, finding a textbook that talks about trust in the states to get some of the technical.
A textbook, because that's going to be really legalese and stuff. I mean, there's some good stuff out there. I know Rich Dad Poor Dad puts out some good stuff. It's reasonable material that talks about estate planning and talks about these things. I think that's a good place to start. But it's like everything, right? Drill the source down to where it's coming from, and is it credible?
So the advisory is
finding credible information, not
that's right,
not sexy information.
Yeah, something that's salacious that says work with us and no one will ever pay taxes forever. And you're like, okay, that's an interesting
And if
byline.
someone's telling you that you can protect your assets with a grantor trust, well, run.
Yeah, and that's a key. That's a key notable fact.
So if people are talking on the internet about using trusts to protect assets, run. Because
So-
if you're going to protect assets,
Yeah,
if you really want to protect assets and you're really serious about doing that, that is a really long conversation. There's a lot of nuance to it, and you've got to have an attorney who specializes in asset protection,
that's right.
because you really have to know. And that attorney, ask him, do you have bankruptcy experience?
Mm-hmm.
Do you have experience with complicated trusts? You know, how many asset protection schemes have you come up with? Because if they don't understand the bankruptcy law, if they don't understand Uniform Fraudulent Transfers Act, if they haven't been in court litigating this stuff, run, because they don't know what they're talking about.
Yeah. So with that, we summarize by saying those that are interested in just learning more about their estate planning is find information that is credible, do some of that learning, and then learn about finding the right professional, asking them the right questions. Like you said, what kind of experience do they have? Really drill down into whether that professional you're working with has the right experience for your circumstance. And then from there, really think holistically about how you want post date of death and also assets to be controlled throughout your life.
And I would say this too: if you're selecting a professional and you do go to an attorney, which I have to say I recommend, because I've seen what happens when you don't, and more often than not, it's not good. Do you get to meet with the attorney personally?
Mm-hmm.
Critical. Does the attorney spend time with you explaining to you what it is you're doing, why you're doing it? Do they talk to you about how to select a trustee? Are they answering your questions thoroughly? Or are they just, here's our questionnaire, fill it out, and then I'll give you a trust? And if that's the attorney that you're getting,
Yeah.
run.
Yeah.
Find the guy who's willing to spend the time with you and, really talk through with you what it is that you're doing and why you're doing it, so that if you don't feel like you understand what you're doing, don't.
That's a good ending comment. If you don't feel like you understand what you're doing when it comes to your trust, don't. Find another professional.
Find someone that's going to explain it to you.
So with that, I hope our listeners have found a lot of value in some of the discussions we have, because we have these types of conversations with clients on a very, very regular basis. But if anyone out there is done with this episode and wants to learn more, definitely check out resources online. Check out resources we posted in our blog on our website. Thank you, everyone, for listening. And subscribe, ask us questions. We'd love to hear from you all. Until next time.